All right, we are now joined by the Public Protector Advocate Busisiwe Mkhwebane via Zoom to give us some clarity on this matter. Advocate, a very good evening to you, and thanks very much for joining us here on SABC News.
Good evening, Flo, must I say, Advocate Bawa,
Still to come.
and to your listeners.
Yes. All right. Let's start by talking about this letter, which was sent to you from the office of the acting public protector, stating what seems to be termination of legal services and representation. The justification I saw that was made there was that there's no funds and that the proceedings have now exceeded the estimated period, and therefore those estimated costs. We'll come back to your response in a minute, but what does this then mean for your legal rights? What does this mean legally?
This legally means that my legal team, I cannot give instruction to my legal team, not knowing who's going to pay them. And that letter from Advocate Galega started the whole problem, because it was even written to the Speaker, to the Chairperson of the Portfolio Committee on Justice, to the Chairperson of the Section 194 Committee. So the problem is that this started even before then. Let me say that to you and to the listeners. What I'm saying about that is that, remember, since the beginning of the hearing, I indicated that I'm participating under protest, but then I said I'll respect the parliamentary process. And even before then, I was raising various legal issues with the Speaker, with the Chairperson. We've taken the matter to court. I'm represented because of the same process which I had to follow, take the matter to court up until the Constitutional Court. And the Constitutional Court was very clear that I must be represented, or the head of a Chapter 9 institution must be represented, must have full legal representation of her choice. Yeah. So that's one of the successes of always bringing such issues to the attention of the Chairperson and members of Parliament. So it means then I am not legally represented as we speak, and unfortunately I cannot participate in the process until such time the matter of resources is resolved. And on Friday, I've even indicated to the Chairperson that, since the office doesn't have the resources, and we indicated at the beginning that we thought the process will take possibly around 35 days. But then, unfortunately, we didn't have control over this.
Yeah, and in your response to the acting public protector, you've said that you differ sharply from the acting public protector's interpretation of the legal obligations which arise from the High Court, as well as the Court decisions regarding funding of your legal obligations. You've touched on it briefly, but let's talk about the bone of contention here and where exactly you and the acting public protector are really differing at this point. What is she saying that's fundamentally different to what you're saying and what the High Court and the Court decisions had said?
I don't think it's proper for her to even second guess what the Constitutional Court has said, firstly. Secondly, understanding that the resources of the institution are exhausted, but it's not for her to come back again. And even, what is happening currently with this Deputy Public Protector is unheard of, because she has withdrawn several representation which I had to defend in court. And those litigation processes were as a result of me being the public protector. So she withdrew the application for Section 18 actually when I challenged the legality of my suspension, and we had to apply to the Western Cape High Court for them to allow me to return to office while the matter is being litigated. or taken to the Constitutional Court, which judgment we are still waiting. I think it's 4 months now. So she then also indicated that she won't be paying for my challenge of the National Director of Public Prosecution to decide to prosecute me on the matter of alleged perjury relating to the Reserve Bank matter, which is part of what I'm defending myself before the committee. So whatever behavior and her taking decisions, her even challenging those matters in court, sending attorneys and senior counsels to be on watching brief, those things, they haven't taken them into consideration.
Yeah.
And now I am trying to defend this matter. So hence I said even on Friday, it's concerning because it's as if then, there is something which I don't know, which they know with the CEO, or she is blocking all my efforts to go back to the office, and I don't know why, but at any rate, I think it's for her own benefit as well, because she's currently acting as the Public Protector, and I mean, that's why maybe she doesn't even support me, because I would expect her to support me as the Public Protector of South Africa, so that we can resolve this matter. Indeed, I want to be accountable. I want to account.
Yeah.
But then, she is also possibly interested to be the Public Protector one day. And whatever processes, whatever interpretations, whatever obstacles which are being placed on this process, they might come back in future and haunt them, because I think one is trying to make sure that whoever will be facing a situation like this is treated fairly, is treated, their rights are respected. I mean, currently my rights are violated, and I'm not supposed to be raising those concerns.
Yeah, and you did point out that you didn't invite, nor did you impose this inquiry to begin with, and that in each application for temporary suspension of proceedings, you were in fact seeking to avoid these sort of costs and this spending that has happened as a result. Has that ever been taken into consideration? The fact that you have said we should be actually saving the public purse by not continuing with this process, and what then happens at this point now?
During my opening address, when I was giving testimony, I mentioned all the instances where I had to write to the speaker. Firstly, they didn't have the rules. I wrote back to the speaker, can you have rules? Because you cannot just move and say Section 194 says we should initiate this process. They had to go back and draft the rules. After drafting the rules without consulting with the Chapter 9 institutions, and then they gave us the rules, which were even not including the right to legal representation and other gaps in the rules. I raised that. They didn't listen. We had to go to court, and until the Constitutional Court, when the issue of my right to legal representation was dealt with, and currently I'm legally represented. Always, when it started the process, we raised challenges. You cannot, the process has not started. This is what you need to be doing. The issue of the suspension, the president rushed to suspend me whilst the matter was still before the Western Cape High Court. So, and always we write, we plead with members of Parliament, especially the Section 194 committee, but then as well the speaker. But our cry and our pleadings are falling into deaf ears. But what I'm saying is we are always trying to save on the costs. I never brought myself to this particular process. It's the first of its kind. It's like they've been saying, all of them, always, you must account to Parliament. This is what you are supposed to be doing. I'm there to account. Why must I pay for myself? They should be paying. And I still repeat, the institution, they don't have the resources. Zondo Commission was supposed to be for 6 months. It was postponed for 4 years, up to a cost of 2 billion. They managed to find funds. I'm willing to account, let them find the resources for me to proceed, because my legal team, they are representing me on a number of matters, 4 or 5 of them, which the current Galega has withdrawn legal representation so that I can exercise my rights. So they are doing those pro bono, and they've got families as well, which they have to feed. So, I mean, this process, and I said to the chairperson, why can't you also, how much have you spent? Now the issue is, no one is speaking about how much has been spent for the evidence leaders. From where they are getting the resources, let them go there and get the resources so that we can proceed, because this is a good process for me to present my side of the story. I've been sitting there for 8 months, listening to more than 20 to 24 witnesses, and some of them, not presenting the truth before the committee, and also the very same judgments in the Amazon motion. And I must indicate to the listeners, we tried to save the cost, because we said, why expand and go back to Mazoni motion? And they didn't listen to us, because we were saying focus on the panel report, which was dealing with matters where they were saying these matters are, we've got prima facie evidence, come and account on those matters. I mean, some witnesses who were called Abobaloyi and some other matters, which the panel said, those matters, there's no prima facie case, they cannot be entertained.
Right.
And 90%
let's leave it there. Unfortunately, we are out of time.
Court judgments.
Unfortunately, we are out of time, Advocate. Thanks very much for joining us here on SABC News on the late edition. Advocate Busisiwe Mkhwebane, Public Protector, speaking to us, of course, on the back of the fact that there's no resolution at this point to the issue of the legal fees in her parliamentary inquiry case. We'll certainly keep you updated on that particular story.